Good morning, everybody. Thank you for joining us this morning to talk about legal precedents for NFTs. I'll let everybody quickly introduce themselves.
Hi, good morning. My name is Simon Grunfeld. I am a partner in a fractionalization platform called Akimona.
My name is Brian Klein. I'm a litigator. I represent a lot of people in the crypto space, NFT space. Some of the cases or clients have been Charlie Shrem and Block One in their SEC settlement, engaged in courts all around the country for clients.
Hi, my name is Aly Sosa. I am principal at Meta Legal. I advise blockchain, NFT creators, developers. Some of my clients are Deadfellas, Smiles, DVs, just several in the project.
So this morning, I think we're going to say a few quick things, and then if people have questions, we'd love to take some questions. And just thinking about this from my perspective as a litigator and someone who goes into court, there still is a lot of, even though there's been Bitcoin around for almost a dozen years, or louder, please. Sorry, is that better? Thank you. What I would say as a litigator, looking at the space, for the last dozen years or so in the development, there's still a lot of unknowns, and NFTs are the latest unknown in terms of what courts might do. Of course, you can have traditional disputes between founders or companies, but in terms of how a court's going to try to understand what an NFT is, because there can be lots of different types, what the rights that are attaching and how they might resolve disputes, or if there's an investigation by a regulator, there's just a lot of unknowns. And I think that's what makes this one of the things interesting about this space. There's a lot of room for innovation, but there's also a lot of room for legal pitfalls.
So what we do is we have a crowdfunding platform that's SEC registered and approved to issue tokens. So think of us as a Kickstarter, first and foremost, that instead of issuing paper certificates, we actually issue ERC20 tokens directly to the users' wallets upon the offering commencing. And so that's first and foremost. So what we've been doing now is we've been looking at bringing on different companies that are looking to fractionalize themselves either through a token sale on our platform, and we've been catering to actual real-world assets. So we have actually a few sports teams coming through our pipeline right now. They're tokenizing themselves, letting the fans kind of invest in them. We have a movie that is doing a crowdfund over our platform that is going to actually it's not one movie, it's a 6-part docu-series, I think, on Netflix or Amazon, one of those two. And they're going to be documenting the first family of mixed martial arts. And then we have a music platform, at least one, that's also going through the platform right now so that we can tokenize effectively either a musician's songs or the portfolio of songs, what have you. So we decided to now start to expand a little bit our horizon and not just look at actual real-world physical items, but let's take a look at NFTs. Let's talk about fractionalizing NFTs, ownership through the same kind of platform we've been offering it to customers with physical assets, but now we're looking at how we do it in a digital format. How do we make sure that we still maintain our SEC compliance as a FINRA member? By maintaining a non-centralized model. By doing so, we know that these tokens that are issued ultimately will also be available for buying and selling on secondary markets. So very long roadmap ahead of us on the compliance side and on the tech stack. As you can imagine.
And what are the legal precedents they should be looking at or thinking about?
So some of the things like you mentioned, right? It's the wild, wild west. We don't know what might come out first. I personally think the lowest hanging fruit, we've got rising issues and rising attention on roadmaps, particularly in degen projects. We've got roadmaps that are promising X, Y, and Z, half of which are not hitting their marks, which raises issues of consumer deceptive and just a class action could arise from that. I think that's probably the first thing to come. People are just within the community are being put off by certain roadmaps or certain promises. So I think that's probably the first thing
And what about fractionalization, though? That often raises a lot of, from a legal perspective, and I'm not sure how you dealt with that, but it can be considered a securities offering potentially, or may have other issues arise from it.
So I personally don't agree that fractionalized NFTs should have that heightened scrutiny, right? Especially if the individual that's offering the fractionalized NFT isn't managing the tokens, isn't doing anything. I mean, you could just say, here's my CryptoPunk, I'm gonna split it up in 10,000, and I'm not gonna do anything else with it. I'm not gonna attach utility to it, I'm not gonna attach anything with it. How is that a security? I just don't, I understand that, what is it, Crypto Mom? What's her name?
Hester Peirce?
Hester Peirce said to be careful with fractionalization, but I think it all just comes down over management. I think the same thing is going to be over DAOs, right? The hot thing's a DAO, everyone's trying to create one. I would say conservatively, probably 75–80% aren't doing it correctly. They either aren't tethering it to a legal entity in which you're exposing yourself to risk on your personal assets, or you're having a gazillion members in a DAO, which you really should be capping it at 99. There are legal structures in place that will be able to cater to multiple members, but you have to do it right. So I think one thing that I'm hoping to see in the future is DAOs being recognized ubiquitously. Right now we've got the Wyoming LLC, you've got the blockchain LLC in Vermont, which is similar to the Lao. But if you form an LLC in Wyoming and then you get litigation in California, they could litigate you as a general partner. So yeah, I'm hoping that hopefully across the board we'll see recognition of DAOs as a legal entity and structure. We're starting to see it abroad in Panama and Singapore and other places. Otherwise it's considered a mutual fund. You require public disclosure, different registration. So, and you can't just say, hey, I'm just going to plug in a bunch of DAOs, each at 99. You really have to make sure that each one has different voting rights. They're actually voting to what's material of the organization. So there's a lot of considerations in place. It's not just, let's all get into a DAO.
Well, I think what you're saying raises an interesting issue, which is, of course, there are traditional legal frameworks for lots of things, mutual funds, other types of investment funds. And the question is, how are regulators going to view, sort of this novel new space, because it really is a new developing space? Are they going to take their traditional lens, the legal lens, or are they going to try to adapt and be more flexible? My suspicion is that they're going to try to take the traditional frameworks and try to maybe put a square peg in a round hole somewhat. So I think that's, if you want to look to the future, I think there will be a lot of tug and pull between different entities and the regulators and bodies about like what should apply to what. Is this really, like to your point, fractionalization? Doesn't have to be a security. There's lots of ways you can do it. Simon, how did you do that?
So from Akamoto's perspective, any project that gets issued over our platform we consider a security. So we just cut straight through. And
is that just to be super conservative?
Absolutely, because it's not just a conservative part of, hey, regulatory might get dinged, or somebody might get dinged because of regulatory, but more than that, now that you are actually stating that it's a security now and you're complying, now you can go ahead and tell all of your potential shareholders, this is how you're going to make money. Okay, so like if there are dividends, we're going to pay you out dividends. If there's governance and voting, you can partake in all that, just like you would any kind of shareholder for any other kind of public company. So we just cut through the chase and just said, you know what, let's just make sure everything is security, and just this is how we keep things as copacetic as possible.
So I have some thoughts on that, right? I feel like, of course, especially when you're advising clients, you want them to be compliant, adhere to any guidance, limited guidance that we have out there. But I think we're also at a stage where some of these ventures, some of these ideas, some of these practices, they haven't been fully addressed. So rather than going through the most conservative approach and just labeling as security, we should push the envelope a little. Like I said, there's ways in fractionalized NFTs or fractionalization is not
Correct.
a particular security. I do think that regulators or legislation tends to come down very traditional. So I'd like us to move ahead the space alongside with councils and accountants and try to set up the most sustainable framework so when legislation does come down, it's advanced enough, there's a structure in place enough that they're not going to be able to just tear it apart. So maybe
Well,
even embrace some of the stuff that the community has set up.
And I think there just hasn't been a lot of NFT specific guidance, even though people say, well, you don't need specific guidance because you can look at all our other guidance, whether it's the SEC, the CFTC, whatever organization, and it would still apply. But I think it is helpful, and when you get specific industry-specific guidance, because I think a lot of people do have questions, and it's hard for even lawyers to know where the answers might be found, or to know what answers may apply to what you're talking about, which is, you want your clients to comply, of course, with the law and regulations of the United States or whatever jurisdictions they're in, but sometimes it's not always easy to figure out what those laws are and what applies and then how to comply with them. I don't know, Simon, I assume you have a legal team helping you.
I hope. We absolutely have a legal team. The founder of the company comes from well over 30 years of traditional banking experience, C-suite level. And, so a lot of the questions that were raised here and throughout the day is kind of like to frame a situation where people are trying to hold everyone's hands and walk them through the finish line and try to make sure that you guys are doing things in a compliant manner, right? Because these are the unknown unknowns that a lot of people don't know about. So our opinion is you're the creators. Okay, you guys have the visions. You guys are the ones that are actually creating the content that are making people's lives better. We can fill in the gap on the compliance and regulatory side. We can fill the gap on all the tokenization, on all the tech. And that's why, so with music or with movies or anything of that nature, just focus. You do you, okay? You stay in your lane, we'll stay in our lane, and just make sure that you don't have these concerns and these worries. But I do have a question. So what do we think the threshold is going to be with regard to when either SEC, CFTC, or anybody else starts to come down on certain DAOs or organizations? Like, at what point, what's that tipping point for the size of that organization until they become a target?
Well, in my experience, a lot of times the regulators learn about things the same way everyone else does, by reading the news or following on the same sort of channels everyone else in the space does, whether it's CoinDesk or whether it's a Reddit forum. They are monitoring all those things, and they pay attention to that. And so a lot of times the way they read about things or find out, I've had clients, like, there'll be an article in the paper and the next day they get a subpoena. So, that just happens because they're like, oh, let's look at that company. What are they doing? Let's look at that individual. What are they doing? Or maybe it's a request for information. It doesn't always have to be, as heavy-handed as a subpoena. But I think the threshold is the NFT market has obviously exploded and gotten a lot of attention. I think they're probably less concerned with what looks like more traditional things that are truly non-fungible, individualized products. But I think they're paying attention. I mean, the market's massive and it's interested. And I know, for example, that people in those bodies, these are exciting cases for them to look at because they've been doing the same thing for 20, 30 years, all the same products, and now all of a sudden they've got this new space, and it's exciting, and it gets headlines for them too, right? I mean, it gets, whether it's the SEC or the CFTC, it garners them attention and headlines.
Yeah, I think they have their hands full right now with crypto. By the time they come down to NFTs, it'll probably be more on AML concerns, anti-money laundering, and tokenization way down the line. But
yeah, I think a big issue that's easy to spot is, there's OFAC, which sort of monitors whether, people are engaging with jurisdictions that we're not supposed to be, like Iran, right? There's a lot of sanctions. And so I think that OFAC is a pretty nimble, quick-moving body of the U.S. government, and they're often do come in first.
Yeah, we've got FATFA too, who's advising, that we're a part of. I had this conversation briefly with Jody as far as the KYC, right? And right now the burden lies on the creators to do your KYC. So every time you're selling something, you're supposed to ensure.
KYC is know your customer, by the
Know
way,
your
just for those who
customer.
aren't lawyers.
Sorry, just saying. I feel like it's a ubiquitous term, but I feel like that's going to change. They're going to start imposing that on the platforms to put some sort of mechanism in place, removing that from the creators. It's not sustainable. You've got millions of creators expecting them to do KYC on each and every transaction, especially when they're launching on another platform. It just seems unrealistic. We did want to open this up, sorry, at the 10-minute mark, but got a couple minutes to do Q&A, so if anyone has any questions.
You,
We
sir,
have
right there.
someone- Yeah, could we have someone bring him a mic?
They're going to do that. Thank you.
Hello? Testing.
All right, I'm just gonna scream.
We can hear you.
Great, great. The panel right before had Cruiser Dow, and the subject came up, the fractionalization of their dog NFT, right? And the tokenization of it. And they kind of said, hey, look, this is an art, and this is for art, this is not an investment. But they also had a roadmap that said, hey, we want our community to build upon itself into a treasury to fund projects. Where does that fall into your understanding of things where, they're not promising that this is an investment, but there is a sense of a decentralized organization that builds value and projects upon that?
So, I'm a litigator. I like to say I don't give opinions, I defend them. But I will tell you that anytime you have a project where it gets attention, where it may seem to somebody that it's based on the efforts of others, is why it becomes more valuable, that naturally the SEC may be interested in something like that. Now, again, it doesn't have to be. Lawyers like to say, and it's true, the devil's in the details, right? It all depends on how you do it. I would tell you one thing, though. When you do your project, it is really helpful if you're very clear in how you describe it. And, of course, you have to be accurate in how you describe it, because a lot of times there is misunderstandings, and it's expensive for a company or a founder or a project to be investigated or looked at based on a misunderstanding. And that does happen. And a lot of times my work, I'm hired for people, I have to go to them and say, yeah, what you're seeing is not what's really happening. And you have to explain it, and then they get comfortable and they can move on, hopefully. So I think it's really important to your question, I would say, that you really describe the project completely, accurately, and consult with lawyers, of course. I don't do that type of work, but.
Yeah, I would say, first of all, if you have to determine if there's an SEC concern, right? Just saying that you're buying additional artwork, you referred probably to the Howey test. You referred to one of the elements, so an investment of money in a common scheme with the expectation of profit from the efforts of a third party. So the efforts of the third party, that last element is really where DAOs can come into place. If it's truly decentralized, if you've set up the DAO with the community in mind, so you didn't set up the structure of the DAO and then just plug in your community, that's arguably not fully decentralized. If you're only having your DAO members vote on trivial things, that's not truly decentralized. So I think it's in the details, the disclosure, but also the structure, just ensuring that if you are engaging in anything that you want to maybe circumvent from being considered a securities, you ensure that the last element of the Howey test, decentralization, is actually in effect.
And I'll tell you, I had a client, and the SEC had this case called the Dow Report, right? They issued this Dow Report, which people look to, and I had a client in that case, and it was helpful in our case to really explain to the SEC what my client's involvement was, and help sort of make them sure they understood accurately what was happening, at least for my client. And I think that's where a good advocate can help you, is someone who understands your industry, your product, has a passion for it, but also can then explain it. Because lawyers do speak a different language than everyone else. And when we talk together, it's sometimes unintelligible to others. But that's just the way it is. Simon, what are your thoughts?
Just for a record, I'm the only non-lawyer on this panel. Okay.
Yeah,
so
he
I
drew
know
the
what
short
he's talking
straw.
about. Yeah. To cut to the point, the way we would look at it is that it's a security right off the bat. Doing it through our platform makes it a security. There's no confusion there. Yes, you can kind of skate in that gray area and make sure that your language that you're using adheres to SEC and FINRA compliance. But if you want to state, yes, this is an investment, it's automatically a security. So that's the way we treat it immediately on our
So
platform.
you take a very,
just direct, yeah, just cut
Very
right through it.
binary approach.
Yeah, thank you.
but obviously there are products that aren't securities that aren't on your platform, of course. And so but your approach is,
Our approach is that if you are in the business of either crypto, NFTs, any business actually that wants to come to our platform and tokenize yourselves, we consider it securities, period, full stop. There is no question. We remove all the doubt, and we handle all the regulatory and compliance part of it, the tech stack also, leaving you guys the freedom to just focus on your creative.
I have another question.
I'll try a shot at it. Quick question, follow-up to you. If it is a security, then wouldn't the investors get locked for about a year without any kind of liquidity
If-
in the secondary marketplace?
Right, so if they are non-accredited, then they do get locked up for a year. Okay, that's another reason. Why is there a lockup period? Why do you think there's a lockup period? You know the answer, but maybe they don't. No? Okay. Pump and dump. All right? So you have a 1-year lockup period. It guarantees there's no pump and dump. This brings a lot of value to your project. Okay, it means it holds water. That being said, accredited investors can do peer-to-peer effective immediately.
we have a few more minutes here. Are there any, I see a question, there's a couple questions in the back. Sir? Oh, sorry. Well, I know a number of countries have set up fintech sandboxes, right? And there are states, yeah, there is a lot of innovation, and I think everyone here welcomes that. It's just the question of, you have to really understand what that sandbox does and how much freedom it gives you to innovate within it before you might trip over another jurisdiction's rules and regulations. So I think it's a good question, but I think you really have to go to a lawyer and really understand what you're trying to do and how you fit into that. And then oftentimes you have to really draw a circle around your project and keep it pretty contained.
Yep. I'm not going to add to that because we have 2 minutes and another question, so let's just go for that one.
More niche-oriented, how have you seen NFTs affect the e-discovery market or issue of litigation? Increases costs and decreases costs?
Well, I think,
Intersection at all?
yeah, I mean, electronic discovery, just so everyone back up, when you file a lawsuit or you're involved in any type of litigation, you often have to produce documents or information. And so, depending on how the information is stored and reviewable, it can become more complex and more difficult. So it really just depends on the situation. And e-discovery has really exploded in terms of like the volume. A lot of cases I have, you get gigabytes and terabytes of data. It's very difficult and expensive to navigate for the clients because obviously it takes a lot of time and effort to do things like upload it, review it, and do that stuff. So I think there will be challenges, in any field where it's very digital.
Yeah, I would say, keep that in mind with your Discord and Telegram. Maybe not so much with Signal, but
You also have a duty to preserve things if there's a lawsuit or a regulatory action, and that you should take that very seriously.
Go ahead. Sorry.
Just as there's been some talk at this conference about as individuals joining the DAO or just buying tokens in the DAO, you could be interpreted to be taking on a partnership position and open yourself up to civil liability. Just want to get your opinions, thoughts on that, and what individuals could do to protect themselves.
Well, it really depends.
so one of them, like I said, you want to ensure that at least it's pegged to an LLC, so at least there's some recognition that your personal assets aren't at risk. Another thing I'd recommend is probably entering a DAO through an LLC. So rather than your personal name, assuming the LLC is relevant to whatever the DAO is doing, so you are adding another layer of protection should litigation arise outside of Wyoming and the DAO were to be treated as a general partnership, then at least you're a member through it from an LLC rather than your personal self.
Unfortunately, we've run out of time. Thank you very much.
Thank
We'll be
you.
around if you have questions.